Evening, everyone, and welcome to GAE Writes at Night. And this is our final Writes at Night session for this year. It is December. We will be continuing this series of sessions about our legal rights in the spring, starting in January. So we will invite you now to go ahead and register for those sessions. Our topic this evening is about the GAE lawsuit against the state of Georgia concerning the school reopenings. And I want to say the school building reopenings because we have all been teaching and our students have been learning every single day since March 13th, just not always in the building. So this is the topic this evening. And before I introduce our guests, I do want to let you know that we are putting in the chat the link to the survey, and we are asking you to ask all our members, all your colleagues, to complete this survey. And then once they complete the survey, to also sign the pledge that they are in agreement with us asking for safe and healthy learning environments for all of our students. So it is gae.org/survey. And then at the end of it is the link to the pledge. At this time, I would like to introduce our GAE General Counsel, Mike McGonigal, to tell us more about what we're going to learn tonight and to introduce our very special guest. Mike?
Thank you, Lisa, and good evening, everybody. I hope everybody is staying warm in this chilly weather. Well, tonight we are very honored to have NEA's General Counsel, Alice O'Brien, with us and giving us some of her precious time to speak to us tonight about the NEA GAE school reopening lawsuit. Just briefly, I want to remind folks that Alice has been in the role of NEA General Counsel for a little over 10 years. And I remember her coming in very well. Before that, she was General Counsel to the California Teachers Association. And before that, she was a lawyer with the Bredhoff and Kaiser law firm in Washington, D.C. Alice, and I don't know what your undergraduate degree was in, but it is from Yale, and you have a law degree from Georgetown. So with that, we are very, very, very honored, and it is my pleasure to introduce to you NEA General Counsel Alice O'Brien, who will begin a conversation about the school reopening lawsuit.
Thank you so much, President Morgan and Mike. It's really a pleasure to be here tonight. I love getting a chance to hear from members directly about what is actually going on. And so this kind of format gives me a chance to do that. And that is really instructive and useful. And I appreciate you taking the time tonight to sign on to talk about this lawsuit. So I'm going to give you just a very quick overview about what this lawsuit was, why we filed it, what the claims are, what we hope, what our greatest aspirations are in terms of what we could possibly get out of it, and what the timeline is. And then happy to answer questions from everybody about it. So we filed the lawsuit at the beginning of October. NEA, in partnership with GAE, put together the lawsuit. And the lawsuit is against Governor Kemp, the state superintendent of instruction, the state public health commissioner, the superintendent of the Paulding School District, and the school board members of the Paulding School District. That may sound like a little bit of an odd group of defendants, but it's going to become clear to you once I talk about what the claims are, why we have that assortment. So the first claim in the lawsuit is that the state of Georgia, as a matter of state constitutional law, has an obligation, had an obligation, and continues to have an obligation, which it continues to fail to meet, which is to provide some basic health and safety mandates, protections for students and staff in the school reopening context. And so what does that mean? It means when Governor Kemp, over the course of last spring and the summer, issued multiple executive orders, including many orders that provided very detailed dictates as to how private businesses were to open, what was to happen in gyms, what was to happen in restaurants, etc. He also had an obligation to do something affirmative to address the situation in schools. And neither he nor his public health commissioner nor the state school superintendent did. Instead, what they have done is they have issued some, pretty weak suggestions as to how schools should operate. And they have declined to mandate any of those suggestions. They have left them entirely to the discretion of school districts as to whether or not they will be implemented. And they have done that on the stated reason that schools may or may not have the resources to implement these, and therefore it's best left to school districts to decide whether or not and how to protect health and safety. And the problem with that as a legal matter is that the state has a constitutional obligation to provide an adequate public school system. And we are making the contention in this case that an adequate public school system includes one that is safe for the school community. And the state, not just locals, not just school districts, but the state itself has an obligation to make sure that the basic conditions are in place for that to occur. So that's claim number one, and that's the claim that goes against the state defendants in the case. The other two claims go to a particular school district, the Paulding School District. And there are two different claims, and I'll talk in a minute about why we are making these claims against Paulding School District in particular, but what they would mean if they were accepted in other school districts across Georgia. So in the Paulding School District, despite the fact that there are high levels of community spread and have been since schools reopened, and despite the advice from the CDC, which has only strengthened, in the last couple of months, the CDC has gotten much more stringent in terms of what they are saying must occur in schools in order to keep people safe. The Paulding School District has not provided staff with any training in order to make sure that the school is being operated, school buildings are being operated in a safe manner, and has not mandated masks wearing by staff or by students, and has not enforced social distancing. They have been very lax, and there are some buildings in the Paulding School District where most of the kids and most of the staff are not wearing masks. And so the claims in the lawsuit that go to that school district in particular are and there have been over 600 cases of COVID cases at this point, according to the Paulding School District's own weekly reports that have been reported in the school district. So the two claims that go to the Paulding School District are, number one, by not enforcing sort of basic minimum standards, meaning masks and social distancing requirements in the schools, the Paulding School District is effectively creating a public nuisance. They're creating a place where where COVID spread is occurring and is continuing to occur, and that is detrimental to the community. It's a public nuisance, it's a public health hazard, and the lawsuit asks for them to enforce mask requirements and enforce social distancing requirements in order to end the hazard to public health that their conduct is creating. So that's the first claim against the school district. The second claim against the school district is that by operating in this manner, the school district is violating the right of staff to a safe workplace. That when staff go to work, they have a common law right, that means a right under the case law of Georgia, to have a safe place of work. And the employer has an obligation to take reasonable steps to make that so. And here the Paulding School District is not doing that, because the Paulding School District, because of a political divide on the school board, actually, they are split 3-3 between people who vehemently support masks and people who vehemently oppose masks. They are not enforcing masks, and they're not enforcing social distancing. So there are many other school districts in Georgia who fit exactly the description of Paulding, and we know that. The reason why we picked one is because frequently in litigation, we pick a test case on the theory that if we win the test case, then we can use that precedent in order to spread compliance across a whole state or across a whole nation without suing every school district individually. So our plan, our aspiration is to seek a ruling against the Paulding School District that we can then use to advocate around for the same result in other school districts across Georgia. The remedy that we're asking for on all these claims is declaratory and injunctive relief, right? We want an order from the court requiring the state defendants to establish minimum standards to protect students and staff in schools. We want an order from the court to the Paulding School District defendants requiring them to do the same at the school district level. And we want a declaration that the state defendants and the school district defendants have these basic obligations that they must fulfill. And so obviously this case is, important for GAE, but it's also important for NEA. In this school reopening, now I was going to say moment, but it's not moment, it's months, right? It's 9 months at this point, and it's going to be months more. We know that there are many, many places where the safety of students and staff have not been given the protection that they should be given. And we also know that despite our advocacy to date, we have not been able to get all the protections in place that we need. And so we are turning to the courts because we need to continue to advocate for and press for real protection for our members, and that our member rights be enforced and respected. So that's a, I guess, couple-minute overview of the lawsuit and why we filed it and where it is. We filed the lawsuit, I guess the two other things I was going to say in this opening little bit is I wanted to say we filed the lawsuit at the beginning of October in Superior Court in Fulton County. And we intend to move forward with motions in the trial court in the coming weeks in order to continue to press the lawsuit forward and try to get a remedy quickly in the lawsuit. That said, litigation is never a quick endeavor. The state defendants and the local defendants have not even answered or responded to the lawsuit yet. We expect them to do so in the next couple of weeks. So this will continue, the litigation will continue to play out over the next several months, I would expect, before we get a ruling by the trial court in the case. So with that, let me...
Yes.
throw it open to questions.
Okay, yes. And again, participants, anyone who has a question, if you will put it in the chat. We did have a first question, and you did such a wonderful job. You have already answered that person's question. They just and that, but I want us to reiterate that, however, because it's a concern that I have heard from our members across the state. Why Paulding? And will this impact my system? Because members across the state are having that similar experience. So can you let them know again that, yes, it will
Yes.
provide them
So
with
it will. So it definitely will. We brought these claims in Paulding specifically because we had a plaintiff. We have an individual teacher member who was willing to stand up and be a plaintiff in the lawsuit. And she has a child who is in the school district who has health issues, who was also willing to be a plaintiff. So it was important for us to have individual plaintiffs in the particular school district that we were bringing the public nuisance claim in, because it makes the claim much more powerful. We, of course, have brought the case in the name of GAE too, but the case is more powerful when we have individual names and individual facts to support the claim. But any ruling that we get against the Paulding School District, so if we get a ruling against the Paulding School District that they have created a public nuisance by not enforcing a mask mandate, right, throughout the schools, we can immediately take that and use that to advocate in other school districts across the state of Georgia to require that they enforce a mask mandate or face a similar lawsuit. And those kinds of tactics are very, very effective in spreading favorable rulings in a lawsuit. It's often the case that you don't even really need either a conversation or kind of a exchange with other school districts in a state. Once a school district has lost a case like this, other school districts will come into compliance with what they understand the new legal regime is once there's a ruling against the school district in a state.
Thank you. And Alice, you're doing such a great job. That was actually the next question was, do we believe that other school districts will comply if we win this case? So yes, we do. The plaintiffs in this are anonymous. Can you explain why they are anonymous and maybe why they should not fear the retaliation that many of our members often do?
Sure. So the individuals in the case are anonymous. That means that we filed the lawsuit kind of under anonymous initials without identifying them specifically because they were concerned about retaliation of the school district if they spoke up and advocated in this way. Obviously we want to protect members every way that we can. So we were happy to do that for them. But you should also know that as public employees, when you speak up and advocate on an issue of public concern, your advocacy, filing a lawsuit, going to a school board meeting and saying they should enforce masks, they should have social distancing, they should look at their HVAC system and see if, air is actually circulating in the schools, much less is it being changed over as frequently as the CDC recommends. When they do those things, their speech and advocacy is protected by the First Amendment. And the school district cannot take adverse action against them without violating the First Amendment. And GAE has a long history, and NEA has a long history of supporting GAE in advocating on behalf of any member who is terminated or disciplined in any way for taking those kinds of advocacy steps. Your advocacy is protected by the First Amendment, and that's why you're part of a union. That's why you're part of an association. and your association will stand behind you and advocate for you if you step up and advocate in that way. And I'm going to let Mike pipe in here too, because he's nodding away. But, you know, Mike has overseen this representation and brought this representation for years and years and years. And he's even like gone after me when he said, you really should be supporting this case. So he is a true blue advocate. So I'm going to let him pipe in here too.
I appreciate the opportunity. I was trying to figure out how to give a clapping emoji or a thumbs up emoji, and I wasn't able to figure that out. But it is, to President Morgan's leadership, we've done a Rights at Night emphasizing member First Amendment rights, and it has always been very critical and important to members understanding who we are, and we don't exist as individuals on an island. We only exist together. And we do have a constitution with association rights that brings us together, and rights to speak out on matters of public concern. And we've always had those rights, and they've always been vital and fundamental to who we are, but we need them more than ever. And I think part of what I've been doing here in my work with GAE and Alice on the national level has really been trying to educate members, not only to their rights, but there is no other organization that has the resources to back that up. And we can, we've got the examples, most people on the call know that, but we need to be more evangelical about it. Evangelize more about it, and convince members that's why they should join. We talk about the value of membership. Well, that's, one of the primary values of membership is that we are going to stand behind you, that you should not fear retaliation, that GA is part of a national organization, and we have resources to prove it. And that's another one of the messages of this particular school reopening lawsuit, is that we are part of a national organization and a part of a national movement for change in the school reopening context, but it's also the broader context of our democratic values and principles of who we are. And and it's my aspiration that this lawsuit reminds people that where we are in this period of tumult. We have a lot of work to do in Georgia. As Alice said, we want to expand constitutional rights. We want to, get a ruling that you as public school employees do have a right to a safe and healthy work environment. We're lacking that in Georgia. It's really, we're part of the lawsuit is to get us into the 21st century. That's my 2 cents. That's my 2 cents.
The next question we have is, since the plaintiffs in this case are anonymous, have GAE leaders in Paulding been retaliated against?
No. Mike can answer that too, but no, there has been no retaliation for the filing of the lawsuit.
I haven't had any reports of retaliation. Nothing from central office or building level telling them to, stop speaking up, or we'll fire you, or any threats like that haven't come through. So that's a good sign.
Yes. Okay. The next question, Alice, you may not be familiar with this, but this has happened in several systems in Georgia, that there are signs on the front doors of the school buildings saying that staff, parents, visitors are entering at their own risk due to the inherent nature of coronavirus as a contagious disease. Will this lawsuit have any impact on that situation?
Not directly. I mean, you should know as a general matter that those kinds of signs, I don't know, they may make school district lawyers feel better in some way, but as to students, they are likely not really accomplishing anything because students are required to go to school. And as to staff, I think they're unlikely to be effective at the end of the day in terms of some kind of liability protection for school districts. I do think the fact that, like, if the Paulding School District is posting that on its buildings, it almost seems like a tacit admission that they know they are not providing a safe school, right? If they have to warn people when you walk into the building, well, you are assuming some risk here. That seems potentially helpful in the lawsuit. So I'd ask, we should put that on our agenda, Mike, to check into to see if they are posting those around the Paulding School District.
Yes, the member that asked the question, I recognize their name, and they're not in Paulding, but we do know that it has happened in several counties. The next question, for our members in these districts that are not requiring masks in the building, can teachers legally ask students to wear a mask in their classroom if it is not a mandate by the district?
So I think the best route for a teacher to do that is to make an ADA accommodations claim. And so the ADA is the Americans with Disabilities Act. It protects people who have a condition that qualifies as a disability under the law. And that doesn't mean, in the COVID context, there are lots of people who have conditions that would qualify as a disabling condition for purposes of the ADA that they probably never thought of as a disability before. So for example, diabetes would be a good example of that. Like, there are lots of people with diabetes, they do not kind of think of themselves as being disabled within the meaning of the ADA, but they in fact are, and they do have those rights. Somebody who has sickle cell disease likely doesn't think of themselves as being disabled, but they do have a disability that is recognized for purposes of the ADA. And I name those two conditions in particular, but there are a list of them on the CDC website that put individuals at higher risk of a severe COVID infection. And so if you have a condition like that qualifies you for a disability, you can make a demand for an accommodation from your district in the form of additional mitigation measures in your classroom, including masks for students, right? Limitations on how many people you interact with during the day, limitations on, any requirements that you move from one classroom to another classroom, right? Your accommodation request is going to be unique to you, tailored to you, and the school district has an obligation to engage in an interactive process with you about exactly how to accommodate you. But asking for masks wearing to be enforced in your classroom is a reasonable accommodation request to make, and whether or not the school district grants it or not is something that you can advocate for, and your union, then your association can help you advocate for as well. Mike, do you want to add on?
Yeah, that's an excellent answer, and I'd only supplement it to say that it wouldn't be insubordination for you to make the request under just general education law. Insubordination is defined as a willful refusal to disregard a lawful request And, you know, that's the kind of case we would love to defend if a district would dare to take disciplinary action for a member disregarding a directive not to enforce masks wearing in his or her classroom. And I'm not advocating you run out and do it. But my point is, I firmly believe that that would not be insubordinate. I just can't see that happening. So.
Okay. We've got a couple more questions about the liability. We know our school districts believe that the liability law that the state legislature passed in June does protect them. Will it protect them if the employee can show that they contracted COVID at work? And I know there's a effort to include protections for businesses in the next COVID relief package from the federal government. Will that protect school systems from their liability? Will it impact us in any way with this suit?
So in the state law, I'm gonna defer to Mike. I will say this on the liability issue. Establishing liability on the part of an employer for a COVID illness will be very hard, right? Because it's very hard to prove where you contracted the illness, right? We all live in the world. This is a disease which is spread by asymptomatic individuals and sharing air, right, with people who are asymptomatic. So, you know, people who are kind of out in the world in any respect, and all of us are to some extent, it becomes very hard to establish liability. That said, there is certainly both the school districts and the business community are paying a lot of attention to this liability issue. And I think they are paying attention to it in particular because they know they have dropped the ball. And they know that they did not put protections in place for people. And they know that they have not taken the basic steps that the CDC recommended that they take, and that the CDC has been kind of increasingly vocal in saying that they take, right? The CDC just last week came out and said everybody indoors all the time should wear masks. No ifs, ands, or buts. Everybody, everywhere, if you're indoors, you should wear a mask. If you're not in your home, you know, with people that you live with all the time. And so when employers and school districts disregard that kind of public health advice, I think there is exposure there. And there certainly is a lot of effort at the federal level to try to kind of bridge the gap and provide school districts with liability protection. And that's going to be a continuing fight, which we have been advocating against. But I don't know the state of play in Georgia specifically on that issue. So I'm going to ask Mike to weigh in.
Well, state of play, and it's a little hazy to me. What I can say is the statute, it raises the bar for plaintiffs to get a foot in the courthouse if they wish to file a claim that they contracted lawsuit in the schoolhouse. I believe it raises it up to a very willful, gross, neglect standard. So they've raised it as high as they possibly could. Our advice to members is to try to eliminate or try to narrow down causation as much as you can by, keeping records of where you've been, get a COVID test, and if it's negative, keep that in your documentation, so that if you were to contract it, you still have a right to file for workers' compensation. And of course, that will be hotly contested, as Alice rightly cautions. But if you keep documentation where you've been, if you get a COVID test and it's negative, close to, the time where we believe, we argue that you contracted it on the schoolhouse grounds, you'll be in a better position to at least get your workers' comp benefits, which is kind of where it's at. And I don't know of anybody, any GA member who has filed workers' comp contending that they contracted it at school at this point.
And I want to ask one last question. I do want to go back to the First Amendment rights of our members, because this is something I feel like I want to beat the drum, and I want to say as many times as I can, because I hear so often from members that they are afraid to say anything. I actually heard from a member this week that said, my district has told us we shouldn't be saying anything about what's happening in our school anywhere. And so she's even afraid to tell anyone what's happening in her building. So, Alice, earlier you said that our First Amendment rights count when we are speaking on matters of public interest. So if I'm speaking out about the general happenings in the building, the general things about the COVID and quarantining, et cetera, that is defined as a matter of general public information interest. Is that correct?
Yeah, there are two things you need to think about in terms of protecting your advocacy. One is, what are you talking about? What's the subject matter you're talking about? Like if you're talking about a disciplinary dispute with your employer, that is not a matter of public concern. That's a matter of personal concern. It's not going to be protected by the First Amendment. But if you're talking about, my school district is not putting protocols in place in order to protect people. My school district is making people not report that they have a COVID case in their classroom. My school district is not following quarantine procedures. And so teachers and students who have been exposed to COVID are not being told about it, or are coming back to the classroom before their quarantine period has expired. All those issues are clearly matters of public concern, right? We were in a national public health crisis due to this pandemic. It is getting substantially worse every single day. And steps that school districts are taking to hide the ball and prevent people from protecting themselves and prevent communities from protecting themselves are all pretty patently, clearly matters of extreme public concern. So that's issue number one. You want to be talking about a matter of public concern, but you also want to be talking about it publicly. Kind of oddly, and this is kind of counterintuitive, but the First Amendment protects you the most if you're talking loudly as a citizen about the matter of public concern. So you're not just talking to your principal, you're not just talking to your colleague in the break room. You are going to the school board meeting and you're making a speech at the school board meeting. You're writing a letter to the editor of your newspaper, and so you're making that kind of public appeal as a citizen. That kind of speech is squarely protected by the First Amendment. So I think the lesson is, be loud as an advocate and be loud in the right places as a citizen in order to get maximum protection of the First Amendment.
I would add my advice to that. Identify yourself as a GAE member. So you're making it clear that you are speaking from GAE's interest in the public concern and not as an employee.
Very important. Very important. Thank you.
The next question we have, and this is a little bit of a misunderstanding. What happens when teachers are no longer considered essential personnel? And what has happened here in Georgia is some of our districts have told educators, teachers, other school employees, our ESPs, that they are essential personnel. However, the governor has never designated educators as essential personnel, despite the fact that the federal government did. So it's in some districts, yes, you are being told you are essential personnel. In other districts, that indication is not happening. And I think that goes to our lawsuit and one of the issues that there isn't consistency throughout the state with what and how this is being handled.
Yeah,
So,
I think that's absolutely right. You know, the essential designation, it really matters for purposes of state rights and responsibilities. And in some states, it's a good designation to have. In some states, it's not. I'll leave to Mike to weigh in on the particulars in Georgia. At the federal level, what the federal government has said is that educators could be deemed to be essential employees. And they've kind of left that door open for states to go through, but there's no sort of binding directive of the federal government that educators must be treated as essential employees. And the reason why it can matter, you know, it can matter because in some states, if you're designated as an essential employee, then the state can require that you work, even if you believe that the conditions for work are unsafe. And it matters for purposes of vaccine priority. Under many, many state plans. I don't know if that's the case in Georgia. You know, states are coming up with plans as to who gets vaccinated, when, and what the priority is. And in many, many state plans, the first category is healthcare workers and residents of long-term care facilities. And the second category are essential workers. And so whether or not educators are designated as essential is an important factor for that discussion.
Yeah, my only top of mind is that Alice is right. We had I believe a memo from Homeland Security come out, and it's just a very dubious memorandum to begin with, surrounding the designation of public employees as essential. And one of the things we've been asking for, you know, you could have, I suppose, a principle using language loosely, perhaps. But if you have that language being tossed around in a, you know, manner, a casual manner, we should be demanding for the district's policy on this. You know, we've been, keep up the pressure, ask for their pandemic plan, if, you know, if they have one. Is it up to date? What does it say? And just where is it written that I am deemed essential and I am required as a term and condition of my job to walk into a highly dangerous situation? So we want that documentation so that we can act on it. So that would be one of my requests, should this come up.
okay, thank you. I think that ends our questions. So I want to thank Alice O'Brien for joining us this evening and all the great information, and thank NEA for supporting GAE and our members in this effort to ensure safe schools for not only our members and our colleagues, but our students as well. Because we all know at the end of the day, that's why we are here and that's what we are concerned about. I will ask all of you who are participating today to please go to gae.org/survey and share with all your colleagues to complete the survey. And then additionally, share with your colleagues what you've learned this evening about the lawsuit and why GAE is acting on behalf of our students and the educators in Georgia. And if they are not yet a member, send them to joingae.org and have them sign now, because we need all our colleagues with us in this fight to truly stand up for our students and public education in Georgia. So thank you for joining us this evening. Thank you, Alice, for being with us. This is wonderful. And we will see you for our next Rights at Night in January. Everyone have a great evening.